This show is intended to help listeners understand the new opportunities that are now available to college and high school athletes as it relates to name, image, and likeness. The information contained in this show is only meant for educational purposes and is not meant to be legal advice or to establish an attorney-client relationship. Hello, and welcome to another episode of Court to Court. I'm your host, Cassandra Ramsey, the Esquire Coach. And today we're going to get into a lot of college sports news. One of the biggest stories to recently grace headlines. And that story is of Vanderbilt's quarterback, Diego Pavia, who has just recently served the NCAA another major blow. And then we're also going to talk about the House Settlement Notice and whether athletes should opt in and opt out. We're going to address some Title IX concerns for the House Settlement Notice. And then we're going to discuss the fact that the NCAA has eliminated its National Letter of Intent program. So let's get started. If you've been following college football at all, you've probably heard the name Diego Pavia. Diego Pavia has had quite the year, as he is the starting quarterback of Vanderbilt, and he has led them to what has shaped up to be a historic season. They beat the top-ranked University of Alabama, and they beat Auburn University as well, and they are set to play in their first bowl game since 2018. But Pavia is now making headlines due to his recent success against the NCAA, where he sued them seeking a preliminary injunction to stop the enforcement of their eligibility rules. Before we get into the details of the case, we should start by understanding Pavia's path to Vanderbilt. Pavia had no D1 offers when he graduated high school, and he attended junior college at New Mexico Military Academy. He played there during the 2020 and 2021 season, but he did not earn any NIL compensation during his time at New Mexico Military Academy. He attained his associate's degree from there and then transferred to New Mexico University during the 2022-23 and 23-24 academic years. He was named 2023 Conference USA Offensive Player of the Year. In 2024, after receiving his bachelor's degree from New Mexico State, he transferred to Vanderbilt University. And as I just mentioned in the beginning, has had quite the historic season while there at Vanderbilt. Pavia wants to play football during the 2025-26 season. However, he didn't have any remaining eligibility due to the 2 years that he played at junior college, even though the junior college is not an NCAA member school. But one of those years was during 2020, during the COVID pandemic, when the NCAA allowed their schools to issue a one-year eligibility waiver, permitting athletes to have another year of eligibility to play their sports due to things being paused during the COVID pandemic. It is for this reason that Pavia sued the NCAA, seeking an injunction, meaning seeking to stop the NCAA from enforcing its intercollegiate competition rules on prohibiting him from playing another season. Pavia claimed that the rules prohibiting him from playing football in 2025 were an undue restraint on the labor market and it violated federal antitrust law. He contended that he needed time to consider his options for next season and to negotiate NIL opportunities. And it's for this reason that he was seeking an injunction to stop the enforcement of the rules, as time is of the essence for him, because Division I football players have a 20-day transfer portal window, and that window is from December 9th to December 28th. So accordingly, he was seeking the injunction to stop the enforcement of the NCAA's rules so that he could have time to consider where he may want to play for the 2025 season and the opportunity to negotiate any NIL deals on his behalf. To be granted a preliminary injunction, the person seeking one must prove a few things, one being that they would succeed on the merits of the case and that they're suffering irreparable harm. And here, the court found that Pavia would, in fact, succeed on the merits of the case and that he would suffer an irreparable harm if not granted the injunction, and the harm being his inability to be able to play football in the upcoming season. Accordingly, the court granted the preliminary injunction, giving yet another major blow to the NCAA. So this This decision has significant ramifications for the NCAA for a few reasons. One being the other athletes who are similarly situated like Pavia can file a similar lawsuit and try to, get the opportunity to participate in college athletics in the same way that Pavia has. Another significant impact of this case on the NCAA is that many points of the opinion have relied on the current changes that have taken place in college athletics and has essentially gutted the NCAA's former defensive playbook in these types of cases. So what do I mean by that? One of the NCAA's defenses in this case was that the intercollegiate compensation rules were necessary to promote their agenda of having athletes make progress towards degree progression. In the opinion, the court was not at all persuaded by that assertion, pointing out the fact that the NCAA's rules now allows multiple transfers and that schools are not required to accept the former school's credits, therefore not promoting the NCAA's agenda of degree progression. This case is also a blow to the NCAA because the court poked major holes into two previous decisions that the NCAA relied on in this case. The first case is Bassett versus the NCAA. The issue there was a coach's challenge to enforcement of an NCAA rule prohibiting improper recruiting inducements and academic fraud. And the second case was Gaines versus the NCAA, where the case regarded the NCAA's no draft rule, under which players who entered the NFL draft lost their amateur status and would be declared ineligible to compete in intercollegiate sports even if they were not selected in the NFL draft. This is important because the distinction that the NCAA tried to make was that those rules in both of those cases were not commercial in nature. So because they were not commercial or really having any effect on the commercial market, those rules should not be subject to antitrust scrutiny. And at that time, that argument held up. And then they tried to analogize that to the eligibility rules that Pavia was challenging. In this case, is saying that those rules are not commercial in nature, so they shouldn't be subject to antitrust scrutiny. Well, the court completely shot down that analysis and said that those cases were decided based on a pre-NIL world, and that that things now have to be considered under what's going on in college sports right now, which there's a major commercial enterprise now for college athletes since they are able to engage in NIL deals and get NIL opportunities. We're going to talk about a little later the House settlement, but if that settlement is approved, we're going to see revenue sharing from colleges with their athletes. Just tremendous examples of how commercial that the college sports is becoming now for the athletes. So due to that, the court found that all of those rules are essentially commercial in nature because they all have an effect on the athlete's ability to enter and move around the college sports market as far as it applies to what school they're going to attend or maybe even transfer to. So that is a major blow to the NCAA because even rules that they were once able to say had no commercial value within the college athletic scheme, so they shouldn't be subject to antitrust law, that argument would no longer hold water because essentially almost every rule now regarding college sports and their movement in terms of what school they decide to attend or be able to transfer to does have a commercial nature because of the new market that is available to college athletes for NIL opportunities. So what would this case mean for the NCAA in the future? As I said, we may see other athletes who are similarly situated make similar claims against the NCAA, but I think perhaps the most important thing is that the NCAA is going to have to take a serious look at their defensive playbook and how they approach these types of cases moving forward. Now we're going to get into the House Settlement Notices. As I have discussed up here before, there's a historic case before the NCAA and college athletics as a whole known as House versus NCAA. That case is three cases that were consolidated together: House versus NCAA, Hubbard versus NCAA, and Carter versus NCAA, where the NCAA and the Power 5 conferences were facing up to $4.3 billion in damages if the cases went to trial and there was no settlement. So as you can see, they worked tirelessly to reach a settlement in those cases. Earlier this year, it was announced that they voted on settlement terms, and those terms were submitted to the court, and the court reviewed them and issued a preliminary approval. just very briefly to discuss what each of those cases was about. So the plaintiffs in the House case sued the NCAA for back NIL payments, lost opportunities to receive NIL revenue from video games, lost broadcasting revenue, and they also sued to allow college athletes to profit from their NIL. But in the meantime, while the case was making its way through the court system, college athletes were granted the right to profit from their NIL, but the case moved forward on the other mentioned issues in the case. The Hubbard case regarded what is known as Alston Awards. So Alston Awards are academic achievement awards that college athletes can now receive as a result of the United States Supreme Court case, Alston versus the NCAA, where the court upheld the lower court's decision to allow college athletes to receive unlimited education-related benefits while allowing the NCAA to continue to limit non-education-related benefits. And in Carter versus NCAA, the plaintiffs were seeking an injunction to stop the NCAA enforcing its pay-for-play rules, and for past damages, the athletes would have been allowed if those rules were not in place. On October 7th, Judge Claudia Wilkin granted preliminary approval of the House settlement terms. So what does this mean for current, future, and past college athletes? The first thing to know is that this is only a preliminary approval, so it has not received final approval yet. There are still several things that need to happen before the settlement can receive final approval. And the first step is that the settlement administrators are required to provide notice to the members of the class about the settlement and their right to either remain a part of the settlement or to opt out of the settlement. These notices were to begin being sent out on October 18th, which was 2 weeks from the date that the settlement received preliminary approval. So, athletes who are a part of the class have until January 31st, 2025 to either opt in or opt out of the House settlement or put forth a formal objection to the House settlement. If an athlete does not opt out or file a formal objection, then the athlete will be automatically bound by the terms of the settlement, and your rights will be affected by the terms of the settlement. So just simply not doing anything doesn't mean that the settlement will not have an effect on you. It still will have an effect on you if you are a member of the class. So which college athletes are a part of the settlement and who will receive notice? Division I college athletes who participated between June 15, 2016 and September 15, 2024 are a part of the settlement class. Athletes in this category are a part of what is being referred to as the damages settlement class. Within the damages settlement class is the settlement football and men's basketball class, the settlement women's basketball class, and the settlement additional sports class. College athletes who compete on the Division I athletic team anytime between the fall of 2025 and the 10 years thereafter are also a part of the settlement class. This is referred to as the injunctive relief settlement class. Both the damages settlement class and the injunctive relief settlement class will be sent notice of the settlement. To simplify, athletes in the damages settlement class may receive about $2.57 billion in damages in total as a group. The athletes in the injunctive settlement class may receive revenue sharing benefits with their respective college or university. Athletes who are a part of the settlement class will begin receiving letters or notices about their inclusion in the class on about October 18th. So you may have received the notice beginning October 18th, 2024. Information about the settlement can be found at www.collegeathletecompensation.com. So per the information on the website, athletes who are a part of the class have 4 options as it relates to the settlement. The first option is to do nothing. However, there are ramifications for doing nothing. So those who do nothing will likely get no money from the settlement and will give up their right to bring a lawsuit regarding the issues in the settlement against the NCAA and the Power 5 conferences, the ACC, Big 12, Pac-12, Big 10, and the SEC, including their member schools or universities. The next option is to participate in the settlement. Participating in the settlement means that you may receive one or more payments if you qualify. And to participate in the settlement, you must update your contact information at that website, www.collegeathletecompensation.com, and you must submit a claim form on the website. By participating in the settlement, you give up your rights to bring a lawsuit about the same issues that are addressed in the settlement against the NCAA and the Power 5 conferences and their member colleges and universities. The third option would be to opt out. This means you will not receive payment. However, you will retain your right to bring a lawsuit against the NCAA and Power 5 conferences regarding these issues, and as well to bring a lawsuit against their respective colleges and universities. However, you cannot opt out of the future changes that will be coming to the NCAA's compensation rules. And the final option is to object. This means to tell the court why you don't like the settlement and don't think it should be granted approval. Per the website, athletes will be able to view their estimated payment amount on or after December 17, 2024. In addition to informing athletes in the class of what their options are regarding the settlement also makes clear that it has no bearing on athletes' rights. In the case of Cho versus Brown University, a case addressing the fact that Ivy League athletes are not awarded athletic scholarships, nor do the institutions provide any other compensation or education-related reimbursement for athletic services. The settlement also makes clear that it has no bearing on athletes' rights in the case of Johnson versus NCAA, which is addressing the issue of employment for college athletes under the Fair Labor and Standards Act. The settlement notice also states that it will have no bearing on athletes' rights regarding Title IX claims, except for those that are related to the distribution of the gross settlement fund. So this means that athletes who opt into the settlement, or who don't opt out of the settlement rather, would be able to bring Title IX claims, except for those that are related to the distribution of funds as it relates under the settlement. So why is this important? It's important because it's going to affect athletes' ability to bring claims regarding settlement distribution under Title IX law. So, for example, it was recently reported that Texas Tech plans to allocate 90% of its revenue sharing distribution to Texas Tech football and men's basketball. So you can see why that may present a problem for Title IX and schools' obligation to provide equitable opportunities to both men's and women's sports. So questions regarding how Title IX plays in a world where the settlement is approved and schools begin revenue sharing with their athletes still remain open, especially given the fact that the settlement has not yet been approved and will not be approved until potentially April, as the fairness hearing won't be held until April 7, 2025. But that presents serious Title IX concerns for how things may move forward under the settlement if it is approved. As I mentioned, this settlement consolidated 3 cases together: the House case, the Hubbard case, and the Carter case. So in some cases, athletes may receive 2 notices under the settlement as they are part of the class in the 2 cases, one being for the House case, one being for the Hubbard case. So that's just something to note for why you may get 2 different settlement notices. So how much will eligible athletes be paid? So payments will be made according to a distribution plan. There will be broadcast NIL payments that will be set for a yearly amount for each FBS football and Division I basketball player based on the sport competed in, specific years played, and the conference competed in. Payments will be equal for members competing in the same sport, same conference, same year. You have video game NIL payments that will be a set yearly amount for each athlete who competed in FBS football, Division I men's basketball, based on the specific years you competed, based on the number of claims filed by the class numbers. And payments for additional compensation for your athletic services will be based on the specific years you competed in Division I between 2019 and 2024, the sport you competed in, the school you competed for, and the number of claims filed by class members, among other criteria. Lost NIL payments will be based on the amount of money you receive from third parties for your NIL after July 1st, 2021, the specific years you competed between 2016 and 2021, the sport you competed in, the school or schools you competed for, your performance statistics, and the number of claims filed by class members. Payments will also be affected by the amount the court awards for fees. Payments will be made over a 10-year period with equal amounts paid each year. Again, as I stated, this is not in full effect yet, as the settlement still has to be approved, and the fairness hearing is scheduled for April 7, 2025. If the settlement is approved at that hearing, then these changes could take effect as early as the 2025-2026 academic school year. In other news, the NCAA has eliminated the National Letter of Intent program. So amidst all of the sweeping changes that has taken place in college athletics, they made the decision to get rid of the NLI program. The National Letter of Intent program started in 1964 and has served as a binding agreement between prospective college athletes and the college or university that the athlete planned to attend and play college sports for. It was created when former Texas Tech President Dr. J. William Davis created the program through the Collegiate Commissioners Association. It was basically an agreement between the player and the school that other schools had to honor and stop recruiting the athlete after the athlete had, signed their intent to attend a certain school. But the NCAA is now stepping away from the National Letter of Intent program, and it will be replaced with a new financial aid agreement that will function similar to the National Letter of Intent program and will likely be tied to the new revenue sharing contract that college athletics will enjoy pending approval of the House settlement. The new agreement would prohibit an athlete from signing more than one binding agreement, and other schools will have to stop recruiting the athlete once the agreement is signed. As you can see, the NCAA, as well as their member institutions, are preparing for the House settlement and preparing like it's, a guarantee that it's going to be approved, because we have a lot of changes being made that are contingent upon the settlement's approval. So April 7th will be a very important day in college athletics in 2025. This will conclude today's episode. Thank you for watching. Please, if you would like, follow me on the various social media platforms that you see running down at the screen, and I'll see you next time.